just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
If John was beaten up and attacked in that house, who did it?
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record.
Okay, here we go. My guess, can everybody hear me?
I can.
Okay, you can hear me, Tom. All right.
Yes.
All right, you can hear me. That's all right. My guest, Tom Mortati, has 3 decades of experience on both the civil, let me try this again. My guest, Tom Mortati, has 3 decades of experience on both the plaintiff and defendant side of civil litigation, and he has won more multi-million-dollar settlements than I have time for in this introduction. On June of this year, Tom was awarded the Daniel Mahoney Memorial Award by the Capital District Trial Lawyers Association for his, quote, outstanding commitment and service to his clients, the bar, and his profession. However, it's his role as counsel for the town of Potsdam, a suit brought on by Nick Hillary, which brought Mr. Mortati to the attention of true crime audiences. And he's been a tireless advocate for Garrett Phillips ever since. Welcome, Tom Mortati.
Hey, Roberta, thank you for having me back. It's a pleasure to be here.
Thank you for doing this. So, we met, I think it's a pretty unusual story. I did a podcast and I was skeptical about some of the claims made in the HBO flick. I can't even call it a documentary, film. I don't know, movie,
Yeah.
TV series, whatever you want to call it. Who killed Garrett Phillips? And you called me up and proceeded to give me, probably for about an hour, all the facts of that case listed off of the top of your head, one after the next, and it was pretty impressive. And a lot of those facts really, hadn't been in the public domain until, at least not maybe in the public domain, but not in the public consciousness, I would think, until we did that podcast.
Yeah.
Got involved with Garrett Phillips and Nick Hillary and representing the town of Potsdam.
Yeah, absolutely. So one just minor clarification, and it was the village of Potsdam. It's somewhat different. It's within the town of Potsdam, but that's okay. The Potsdam Village PD would probably want me to say, no, it was us. Anyway, but yeah, I was involved in that case, within a few months after Garrett's murder, as a result of, Mr. Hillary bringing civil claims against the Potsdam Police Department, which then led to all kinds of things that happened, including discovery that, while I wasn't representing the DA's office or the people, if you will, and there were no charges filed against him. He hadn't been indicted yet or anything. It was a lot of the work from the civil case that he brought upon himself that led to, him ultimately being indicted. In fact, he wouldn't have been indicted, I believe, and wouldn't have been charged officially, but for him bringing it upon himself by virtue of this civil case. So, and I became, in many ways, an advocate for Garrett, because my defense in that civil case was all about, well, I'm going to prove this guy is the one who did it and get his claims dismissed. So, that's been an ongoing thing for me for, well, it was 14 years ago, just a few days, October 24 of 2011, which was just this past Friday, was the 14th anniversary of Garrett's passing. And I will not ever forget that young man. I never met him, but he had a profound impact on my life. So I owe him a debt that I can't repay. And I've been advocating on his behalf in various forums, and much, yours. We've had done several programs together or podcasts together over the years. And I think the first one was 4 years ago, I want to say. And we've had a number since, and it's been great. Plus stepping out into some other cases too, including this one, the Karen Reed case. I can barely hear you.
Yeah, let me take a break and fix this. I'm not sure exactly what's going on, but I'm going to fix it. So let me take a break and fix it.
Okay.
I can hear you, Barb, but I can see it
Mic check, Roberta strides through the static haze. True crime Gotham where the shadows play their plays. Fraudsters fold when a spotlight beams. Fact-focused queen busting propaganda schemes. Glass shatter lies echoes through the streets. Standing for victims, giving voice their beats. NYC Post, truth sharp as night. Roberta exposing she's the anti-fraud light. Hard cash warrior, dissecting state and defense. Twisted innocence, claims breaking pretense. Gotham's truth seeker cuts clean with the blade. Facts in the forefront, no justice gets swayed. Cold facts drip heavy, real talk unfurls. Cracking cases open like oysters with pearls. Innocence gimmicks crumble to dust in the wind. For victims, her creed, justice till the end. Headphones blazing, she drops heavy artillery. Narratives twisted, meet blunt object civility. Roberta got receipts that unravel the ploy, exposing the lies these fraudsters deploy. Glass shatters lies, echoes through the streets. Standing for victims, giving voice their beats. NYC Post, truth sharp as night. Roberta exposing she's the anti-fraud light.
Okay, that should be better. Can everybody hear me? Let's see. Let's see if that's better. Is that better, guys? I'll just wait for everybody to catch up with me.
I can hear you great now, Roberta.
Okay. They're saying it was soft. All right, here we go. Better. Everyone says better. Okay, great. Thank you. So, getting into Karen Reed and this civil suit, what are the challenges for the O'Keefe family? What are the challenges in a wrongful death suit?
So, we'll start with what the case is. Obviously, we know that it's about John's passing. We know when that occurred, et cetera. So looking at the complaint, they sued basically the two bars involved, McCarthy's and the Waterfall, for basically over-serving, if you will, Karen Reed, and that leads to her eventually, killing him and running him over with her car, truck, whatever it was. And then, of course, they've sued the person that was actually behind the wheel, that they claim was responsible for this death. So, and again, this is a civil case, so it's a preponderance of evidence standard that they have to prove their claims by in front of a jury someday, which is, a more likely than not standard, or 51% to 49% when you're looking at it at a balancing scale or a balancing standpoint. The challenges that the O'Keefe family having, the good news is this case was investigated, obviously tremendously so, by the police, the district attorney's office, etc. Notwithstanding the Reed defense, arguments that it wasn't properly investigated. That's a whole, another issue. But a lot of times in civil wrongful death cases where it's just straight up negligence, we don't have all of this other stuff that was done. So in many ways, they benefit from the things that happened. Obviously, on the flip side, there's the incredible publicity. There's the, for lack of a better term, the emotions on different sides of this that we've seen play out on the street corners outside the courthouse during the criminal case, which adds a whole nother layer. And let's face the facts, any jury that they ultimately impanel, it'd be surprising if nobody heard about what went on, et cetera, and as well as the media circus, which is exactly what it was, that, surrounded this case from pretty much the get-go, and especially through the criminal trial and even up to now.
Yeah, and they got the second jury, they got an investigative team to look into potential jurors, and they could not have picked worse jurors than they had picked in the second case. I mean, the foreman was looking immediately after to make deals, to make money off of this. What if you were representing? If you were picking a jury for this case on either side, actually, let's put it on the O'Keefe side. If you were the O'Keefe's lawyer, what kind of juror would you be looking for?
Well, you obviously want somebody that's, first of all, sympathetic to the plaintiff's plight. And what do I mean by that? That's people who are suing for personal injuries, and in this case, wrongful death of a family member due to somebody's claimed negligence. So you want to eliminate the people right off the rip who say, you know what, I don't believe in lawsuits, or, I don't think people should be able to sue for this kind of thing, or, because ultimately what every civil case, and the judge alluded to this in that hearing on the 22nd when he was talking about, hey, folks, you all might want to come together and try to resolve this someday. But civil cases are ultimately only about money damages and awarding of money damages. That's it. We can't do anything else with this type of civil case. So you want people who are willing and able to, hear the claims and aren't bringing in preconceived notions of, lawsuits are crap. There's too many cases out there. And you know what? There are some frivolous cases out there in the civil world, absolutely. But, when you have someone, we know this individual died, and, there's great arguments to be made as to who's responsible. And again, in this being a civil case, the O'Keefe family is saying, both the bars are at fault here for, serving and over-serving. I mean, I think, according to the information, I think she had something like 9 drinks in the span of about 3 hours and 20 minutes. So you have that aspect of it, and then you have her actions as well, being the individual responsible. So I kind of maybe went a little far afield with your question, but you really want people who are going to be willing to listen to the evidence and be patient, because this is probably going to be, just like the criminal trial, a somewhat lengthy affair, which also depends on how much, and we'll get to this in a bit, how much of these additional claims that the Reed defense team wants to bring are in this forum versus somewhere else. But ultimately, Roberta, you want people who are reasonably intelligent, willing to be patient, willing to listen, and to give you a fair shake, ultimately.
Right, and they all say they are, but certainly,
yeah.
And you don't want any. I mean, one of the things we saw with the criminal case was some anti-police biases, sure. And I would think that would be something that I would be asking about if I were a representing the O'Keefe family, which is there's no chance of that since I'm not a lawyer.
Yeah, but no, you're exactly right, because obviously, his background in law enforcement and all of the other, people that were involved here, if you will. But by involved meaning, the folks over at what was it, the McKays and the Alberts, all these people that knew him or were otherwise, I think one of the lawyers referred to as law enforcement adjacent something. So yeah, you need to talk to these jurors and say, well, what do you think about, law enforcement and police officers or whatever? And, you want to get rid of anybody that has a bias against them and say, well, forget it. I'm never going to find in favor of that guy's family because he was a cop. Obviously those people can't be fair. And it takes a lot of weeding out and a lot of asking questions. So, in jury selection in civil cases, it's a lot of tell me why, or you phrase things like, some people are against, the law enforcement system or against police agencies and police officers, and some people are very much in favor. Which side of the aisle do you fall on? And then, you want to tell me more, tell me why, because you want to start pulling things out of people, because it's jury selection isn't effective when the lawyers do all the talking. You want to ask questions, you want to listen to the answers, and keep asking questions to pull out as much information as you can, so you can get rid of people that should be no longer on this jury and can't honestly and effectively and fairly serve. It takes time, and it certainly takes talent.
Yeah, there's like a little clicky noise. I don't know if you're rustling with something that I'm hearing.
Be my mic.
Okay, yeah. Can Gigi's asking, can civil trials be moved to a different county?
So, as a general rule, so what I think she's referring to is in the criminal world, for example, you can seek to have a case moved to a different forum or a different venue within the state because you can't get a fair trial in a certain county. Okay, so that happens often in criminal cases. Civil cases, generally speaking, no. While yes, you can get them moved, it's exceedingly rare for the arguments of like a fair trial, because usually the rules say, hey, a case will be filed in the county in which the parties live, the plaintiffs live, where the defendants are, where the incident occurred. Those are all appropriate venues or appropriate jurisdictions for trial. I can't say it's never happened, but in my 34 plus years now, I've seen two motions in civil cases where they tried to move the venue, not because it wasn't the proper venue. Again, you can have cases get moved because, hey, wait a second, nobody connected to the case is in that county. Okay, that case should be moved. But I've seen two motions in 30 some odd years for moving a case because the defendant claimed, I can't get a fair trial in this county, and I've not seen either one of those granted. So it's pretty hard in the civil world to move it for that type of thing, which is, I think, what that person's alluding to.
Yeah, exactly. Yeah, that's exactly what you'd want to do in this case. Can we move it to a different planet? Can we move it off the? Can we move it to Mars? Nope. Would be the right move? Because there's just been so much pro Karen Reed media and so little. I mean, you talked about how there were people on both sides on the street, but very seldom, mostly it was just Karen Reed flooding the, free Karen Reed flooding the streets, and they got rid of the buffer zone, which I thought was a terrible move. I have so many issues with the judge in the criminal case. Luckily, this judge seems pretty decent, fair. So let's start off. I just wanted to show you so this is the first televised hearing in Karen Reed's civil trial, and this is how it started off. I don't think anything prepares you for this. Karen Reed and her this is the lawyers being introduced.
Good afternoon, Your Honor. Attorney Mark Diller on behalf of the plaintiffs.
Good afternoon, Your Honor. Dan Buck on behalf of the plaintiffs. Good afternoon. Good afternoon. Good afternoon, Your Honor. Damon Seligson on behalf of the defendant, Karen Reed. Okay, good afternoon.
Good afternoon, Your Honor. Charles Waters for defending Karen Reed.
Good afternoon, Your Honor. Alan Jackson on behalf of Mr. Reed.
Good afternoon.
Good afternoon, Your Honor. Erin Rosenberg also on behalf of Mr. Reed.
Good afternoon.
Good afternoon, Your Honor. William Keppel on behalf of Karen Reed.
Got it. Okay,
Good
good
afternoon, Your Honor. Christopher George on behalf of the defendant Karen Reed.
Good afternoon, Your Honor. Marissa Palladini on behalf of Karen Reed.
Good afternoon.
And then we get into the lawyers for the bar, the Waterfall Bar. But it obviously, it seems pretty obvious what the advantages are to having 7 lawyers. You have more people working on your team. You have more ideas. They can see perhaps more legal loopholes. But what are some of the negatives of having 7 lawyers on your team, and how does that and how does a juror look at someone who has 7 lawyers representing them?
So, if I'm a plaintiff's attorney and I see a defense team in front of a jury with 7 lawyers there, I'm probably going to be in the back of my mind thinking, go for it, guys, because a lot of jurors are maybe going to think that person has a lot of money and would be able to satisfy any large jury verdict, award, judgment, whatever. I honestly, so it's funny, when I watched that court hearing initially, I was struck by the number of attorneys who got up and again, it may have been that the judge in that jurisdiction wants to know everyone in the room who's there for a given party. But normally in court appearances like that, whoever's going to do the actual talking is the person who gets up and says something, and the rest just sit there. And the other thing that struck me is, and this is just more of a practical thing, and again, I was on the defense side of the civil world for 26 years, and you got 6 or 7 attorneys who are billing by the hour. That is a huge amount of money that's being spent to have all of those bodies in the courtroom on behalf of one defendant. And yet again, you only had one lawyer actually said anything after the introductions. The first fellow, whose name is escaping me at the moment, the guy with the South African, great accent.
Damon Seligson.
Yes. So, again, going to your initial question is, I really don't think that plays awfully well in front of a jury in a civil case in the end. When you get this parade of people coming in, I think it adds to the circus-like effect, unfortunately, and distracts things. And I would be very concerned on the defense side of the world that, you might be turning some people off. I mean, it's in the many, many, many cases I tried over the years on the defense side of the world, it was rare that I had more than myself there for my given client. Sometimes we had second chairs. And again, to be fair, a large part of that was driven by what the client and or insurance companies who were typically footing the bill would be willing to pay for. But again, it goes back to my earlier point. You got 6 or 7 lawyers in that courtroom who are billing, I'm sure, inordinate amounts of money per hour, and then multiply it by the number of attorneys. And holy smokes, that's a real, in my personal opinion, I don't think it's necessary to have all those people there, especially for an early hearing like that.
What does a civil lawyer in Massachusetts, what would you, for a range of a fee, what would they charge per an hour, would you think would be a reasonable range of a fee?
Boy, so that's a very good question. I don't practice in Massachusetts. I've practiced as a defense attorney in New York, Connecticut. I've handled some federal cases out in the Midwest, and a lot of that is driven by, in the civil defense world, by insurance company rates. Now, I don't think that Karen Reed's probably being defended through an insurance policy. So now you've got people that can charge whatever they want, basically, so, for example, if you were in a medical malpractice case, you've sued a hospital, the defense attorneys are being paid by the hospital through their risk management department and or through an insurance company. Those rates are going to be anywhere from $250, maybe $300 or so an hour, depending. When you have a circumstance like this, you can double that easily, maybe even more for what they may be charging her. I don't know, obviously. I'm not privy to that, what that would be between her and her attorneys. But, man, as a client, I'd be a little concerned about how much money is being spent on an initial hearing. I mean, this isn't even like they're in trial.
Oh, she's always one step ahead. I mean, she's always one step ahead. That's all I can say about
Something like that.
Yeah, yeah. We had exchanged messages before the show, and you had asked me about her attorneys, and we know that she had one lawyer who was on the criminal team pro bono. And there are many versions of exactly what pro bono means, but I don't know. The rumor is that some of these lawyers are working for free. I don't know if that's true or not, just for the publicity of it.
I mean, maybe. So there's certainly, obviously, a ton of publicity to be had from this particular case for anybody involved, and I suppose that could go into someone's calculation as a defense attorney on her team. But that's, you got a lot of people working in theory for free. That's and this is a very time-consuming case, you can tell, and it's going to be even more so given some of the things that the Reed team wants to do going forward by way of the third parties and whatnot. We can talk about in a few minutes, but. I mean, let me put it this way, Roberta. I spent much of the last 2 days working on a pro bono case where I've been appointed as counsel for a former inmate, federal inmate, and that's been a lot of work just this week alone on one thing involving one motion. And the amount of work these folks are putting in on this case is way more.
Wow. The CW, this is a question by Murder by Maestro. Thank you for moderating. The CW referred to the Reed family helping move Karen Reed's vehicle as concealment of evidence. Could the whole family be sued in this case? Because they took her murder vehicle.
So, you mean sued by the O'Keefe family?
Yeah, they went and got it. So she went and got her car, which from John O'Keefe's house, and with her family, and they drove it to her family's home.
So
the police picked it up.
It's probably not an actionable civil tort claim. So you've got a wrongful death case. Okay, so the O'Keefe's attorneys have sued the individuals who could be connected to causing John O'Keefe's wrongful death. Whether they moved the car afterwards or anything else is completely irrelevant. It has no bearing on what caused his death. So I don't see that as being a possibility of any type of viable, what we call cause of action against those individuals for moving the car or, concealing evidence or stuff. Those are things that simply don't typically arise or give rise to tort or civil liability.
Okay, interesting. Let's just go into this, and then this hearing gets a little bit. I found this bizarre. So there's no kind of motion filed. It was just announced in court how they want to bring in third parties into this case. Let's take a listen to Karen Reed's lawyer here.
Those claims stem from the same facts that are at issue in this case. Those claims, Your Honor, are against parties that are not in the litigation at this point, including the Massachusetts State Police, Lieutenant Brian Tully in his personal capacity, Sergeant Yuri Buchanan in his personal capacity, Michael Proctor. Those claims would be in the nature of violations of Karen Reed's civil rights and conspiracy. The claims against the Massachusetts State Police would be negligent training, supervision, and retention of Massachusetts State Police troopers. We also intend, Your Honor, to bring claims, affirmative claims, against Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, and Brian Higgins, who were the occupants of 34 Fairview Road in Canton on the night in question. Those claims will be in the nature of civil conspiracy, violation of Karen Reed's civil rights. and then a claim against the town of Kenton through its police department for negligent failure to secure the garage and the sally port. We asking the court's permission to bring those claims in this case because they do arise out of the same nucleus of operative facts. In order for us to fairly defend Ms. Reed in this case, those claims, those parties need to be asserted in this case. What we'd like
Roberta?
Hey, can you hear me now?
Yep, can,
Okay.
yes.
Yeah. So, is this normal to hear? Is this normal to bring in as a defendant to bring in other third parties as a plaintiff?
Yeah, so it is, and I'll explain. So let's wind back for a second, because one thing that isn't very normal is the complaint, the civil complaint filed by the O'Keefe family was actually filed over a year ago, August 26th, I believe, of 2024. And then there was a stay, if you will, or literally a stay put on the civil case because you had this pending criminal action going on, and you know that had to play out and et cetera, which happened obviously over the course of basically the better part of a year with the last criminal trial. And then you had this conference on September 22nd of 2025. And then approximately 30 days after that, on October 21st, 2025, Karen Reed's attorneys filed their answer to the complaint. The one thing that's a little unusual is that you're having a conference before there was actually an answer filed by the defendant. And the reason for that, though, is because Karen Reed's attorneys, in response to the complaint, initially filed a motion to dismiss a number of the claims in the complaint. So there was the negligent infliction of emotional distress claims, intentional infliction, et cetera. That motion got decided. There was oral argument at the end of that September 22nd hearing briefly, and then that motion, I believe the decision was issued October 3rd, which then triggered Karen Reed's attorneys to serve their answer. So again, it was a little, it happens in the sense that people, defendants make motions to dismiss at the very beginning of a case because they want to knock out elements of a case that shouldn't be there. Okay, that's common. They aren't required to tell the defense attorney, the defense attorneys, Karen Reed's attorneys, aren't required to tell the plaintiff's attorney, oh, by the way, I may be eventually bringing in a third party action. But it's typical that you will have those types of conversations when, in theory, the parties had communications. They would be typically required to have some sort of, informal conference on the phone or Zoom or whatever to talk about, for example, the judge referred to it as a tracking order, which is basically the schedule. So, Karen's attorneys made obviously this very dramatic display of saying, hey, judge and, all the parties involved, we're planning on bringing in other parties to this lawsuit, which is not uncommon. That's called a third party action, where a defendant becomes what's known as a defendant third party plaintiff. So now they're basically saying, okay, plaintiff, you're claiming that I'm responsible for this individual's death and the damages that flow from it, but there's other parties that should be in here that I believe are responsible somehow for what happened here, which is the typical third-party defense type or, third-party complaint that gets filed. So, for example, you have let's just say you have a construction worksite accident where a plaintiff who was injured or killed, they sue the general contractor on the project. And then the general contractor goes and sues other subcontractors or other entities involved. The oddity of Karen Reed's attorney's approach is that the people they want to sue have nothing to do with the wrongful death of John O'Keefe. They all come after the fact. This is, the Massachusetts State Police, the various representatives, you name it, the people at 34 Fairview Road, the Alberts, the McKays, and Mr. Higgins, they're all after the fact. And these are really, while I get that he said these all arise out of the same facts and circumstances, they don't, in a sense that the claims she's making or wants to make against the Massachusetts State Police, for example, are very different claims, including potential federal civil rights claims, which typically get resolved in federal court, which is a whole nother issue of how you litigate if, in fact, the judge allows this. So, he told them at the conference on September 22nd that basically you got to make a motion under Rule 15. So Massachusetts pretty much follows the federal rules of civil procedure, and FRCP 15 is the one that that covers amendment of pleadings and motions to amend and things like that. So, and it is, I think the reason why her attorneys are saying, hey, we're talking about making a motion on this is because of the fact that it's a very different scenario where the parties Karen Reed wants to bring in clearly couldn't have caused his death from the conspiracy standpoint and covering up, et cetera. Although she's claiming, in theory, these people killed him and therefore they're responsible. So it's a very interesting scenario. It's what I would jokingly refer to as a law school question, because in law school, your teachers, tort professors, constitutional law, whatever, on the exams, they give you these absolutely convoluted, mixed up sets of facts and make you figure out how's this going to work. And this is one of those.
Wow. And so that's what I hear what she wants to do is really bring this into federal court. So if he, okay, just say thought experiment, if the judge allowed this motion that we haven't seen yet, that he says within days, I don't know, within days, how many days? It seems like it keeps being promised and never arriving, this motion, but okay. But say this motion arrives, the judge accepts it into this case, which I think is madness, but okay. And is there a way that this judge could say, well, this is really now a federal case, I'm going to move this case to federal court? Could it get moved to federal court?
So, in theory, it could, or parts of it could. So here's the bizarre part again about this. You've got strictly state court-based claims that the O'Keefe family has brought against the two bars and Karen Reed. These are all just state-based claims. They get litigated in state court all the time. Karen Reed, at least based on what her attorney said at the hearing, has also got some state-based claims. But he also said, well, we've got, civil rights violations. Well, a Section 1983 civil rights claim against the Massachusetts State Police, Massachusetts State Police could seek to remove the case to federal court and possibly sever out. So again, this is like a law school question in many ways. There's so many permutations. Let's say that Judge O'Shea, I believe is his name, says, okay, file your motion, and he grants the motion to them for the Reed defense team to name all these additional parties in a third party pleading. The defendants, so the Massachusetts State Police, all of those other individuals, et cetera, they then get served with this thing, and then they have an opportunity to oppose it and or move to dismiss parts of it or remove to federal court possibly. And I'll be honest with you, I don't know how that plays out where you have an initial claim strictly based in the state, tort law, which is the O'Keefe's claim. I could envision a judge in federal court saying, well, wait a second, I'll accept the federal claims, et cetera, that Karen Reed's filing. And she, her attorney alluded to this or stated this. He said, well, we could just file a whole separate action and move to consolidate it. Which, okay, fine. But again, if he files that separate action with federal claims, he's more than likely going to get that thing removed to federal court by the defense attorneys that get hired for the Massachusetts State Police. That's what I would do. That's what I did in my law enforcement defense days. Whenever we had claims filed in state court and there was any federal component to it, we removed it to federal court because that's where you want to litigate federal claims. And I could see a federal judge severing out the original part of it, saying that doesn't belong here. I mean, the procedural quagmire that this thing is going to get into is not going to be resolved for a while. And I know that the judge very much, he's got his tracking order dates with discovery being done, I think, in August next year, and a final pretrial conference, February 2027. I don't know that any of that's going to happen, unfortunately, just because of all of this other stuff that's got to kind of get played out and sorted out. So the easiest thing, I suppose, for the judge in this case, Judge O'Shea, to do would be say, you know what, I'm going to deny your motion. You go file your action in whatever court you want to file it in, and then do with it what you will. But I'm waiting curiously, just like you, to see when are they actually going to file this. I think their next appearance is November. I want to say the last the 21st, excuse me, of
21st.
November. Yeah.
You're right. Yeah.
Friday the 21st, excuse me. I would expect that if Reed's attorneys are going to be making this motion, they will be doing it before then, because I could envision the judge being, hey, wait a minute, I saw you 60 days ago and you said you were going to do this. Where is it?
Then there was this very this was from Mark Diller. This is about 4 minutes of his presentation. I just wanted you to take a look at it.
Sure.
JJ no longer has a voice. His life was wrongfully taken on January 29th, 2022. He lived a life of service. He was a Boston police officer, and his personal life, when JJ's older sister and brother-in-law tragically passed 2 months apart from each other, leaving 2 young children orphaned, JJ stepped up. He agreed to parent those children, to raise them as his own, and to support them. Fast forward to 2022, Your Honor. JJ is involved in a relationship with Miss Reed. It's been going on for a period of time at that time. January 29th, 2022, Karen drives drunk. She reverses her SUV. She knocks JJ down. She leaves him to die in the cold. And Reed knows that she strikes the plaintiff. Rather than seeking to help or calling 911, she returns to JJ's home. There, JJ's 14-year-old niece, Kaylee, a plaintiff in this case, is home alone, asleep. That's when Karen starts plotting. Now, it is significant for the facts for you to understand the context here. Karen Reed knows Kaylee well. She's been in her life for almost up to 2 years. She has served as a part-time maternal figure in her life. She knows that Kaylee is a vulnerable child, having lost 2 parents tragically. And 1 to 2 hours before JJ's body is ever found, before anybody knows his whereabouts, Karen Reed decides to wake up Kaylee in a panic. She tells Kaylee something happened to JJ. He's dead. He's been hit by a plow. Did I hit him? All to a 14-year-old child woken up from sleep who's already lost 2 parents. After provoking this chaos in the middle of the night, Miss Reed leaves Kaylee alone, vulnerable, shocked, and afraid. It's now 1 to 2 hours later. It's at or around 6 a.m. in the morning. JJ's injured body is now found. Right where Karen left him, buried in the snow. 911 is called. Now is when JJ's family learns of JJ's injury. JJ's injuries at this point enter into the O'Keeffe's consciousness. At around 6 a.m., they rush to the hospital. It's 7:50 a.m. That's when the hospital pronounces JJ dead. And within minutes of being pronounced dead, that's when the O'Keeffe family sees their son in the injured state that he was in as a result of the wrongful conduct. From January 29th forward, Your Honor, Karen Reed plots, she fabricates a conspiracy, she launches a public campaign of disinformation, and she involves a blogger named Turtle Boy. She leaks not for public information through him. She pits her followers against the O'Keefe family, and all the while, Karen knows that the O'Keefe family is also vulnerable, grieving another tragedy in their family. The O'Keefes and Kaylee suffer severe emotional distress.
Okay, so what did you think about what kind of job he did with that, with those set of facts?
So he did a very nice job. So first of all, he paints the picture of who JJ is. And while that isn't necessarily relevant to the opposition to the defendant's motion to dismiss certain of the elements of the complaint, namely negligent infliction of emotional distress and intentional infliction of emotional distress and a few other things, he's doing the right things here in setting up this very sympathetic figure, and which is going to be the theme of this case going forward for the O'Keefe family. You're going to hear that, over and over. If it ever gets in front of a jury, with opening statements, you've just got a little preview of it. And he did a really nice job with it. And keep in mind that, again, what he's talking about here are certain elements of time, events in relation to time or temporal events that pertain to what's sustainable at this phase of a case when the defendant moves to dismiss portions of a complaint early on, and what isn't. And I really think he did a nice job in talking about this. And certainly the court, for the most part, found in favor of the plaintiffs here in denying most of the motion to dismiss, which was certainly good for the plaintiffs. And again, this is an early type motion where you're basically looking at the complaint as pled. Does it sufficiently plead facts and allegations necessary to establish the basic elements of the claims you're making?
So how can you claim negligent emotional distress and intentional emotional distress in the same complaint? I mean, if it's intentional, then it's intentional.
It's not uncommon to have them both.
Okay.
In one sense, as a plaintiff attorney, you're covering your bases. If it was intentional, it's based on this set of facts, and if that's not sufficient, or a jury potentially doesn't believe it, was certainly negligent infliction of emotional distress. And what the court was doing here in examining this motion, let me back up for 1 second, was the defendants initially said, hey, wait a second, you can't even have emotional distress claims because they're all subsumed by the wrongful death statute in Massachusetts. The court said, no, that's not the case. I'm going to allow emotional distress claims. Now let's look at the individual claims, negligent infliction of emotional distress claims, and basically said as to the family members, they were there like basically immediately after JJ's pronounced. And because of the temporal relation of those events, their claims can stand. I mean, I believe the actual language in the decision was the complaint alleges sufficient facts that JJ's parents and brother arrived promptly at the hospital upon learning of JJ's death and thus have actionable claims for negligent infliction of emotional distress. The court dismissed Kaylee's negligent infliction of emotional distress claim because her stuff comes after the fact, and basically there aren't any cases that support or create any authority to find negligent infliction of emotional distress for a family member who learns of the death beyond this kind of immediate time frame. So that's why her claim for negligent infliction of emotional distress was dismissed by the court. And just to circle back to the intentional infliction of emotional distress, Kaylee was the only one who had that claim in the complaint. And that was based on actions that, they allege Karen Reed was taking at the time she's waking her up and telling her all these things. And again, the plaintiff's attorneys pled both of these things to basically cover their bases here. And And the court said, the way this is pled, the factual scenario, there's sufficient statements here that could lead to a finding that Karen Reed intended to inflict emotional distress, or that she knew or should have known that the emotional distress would be the likely result of her conduct, which is, another element or way of which you can establish intentional infliction of emotional distress. And again, the difference between the two is, one, you literally intend to do, or you should have known from your actions it was going to happen. And then the other is negligence, basically. So.
Right. So you hear we have this highly traumatized child. She's
Yep.
lost her mother, and then shortly thereafter her father, and then Karen Reed. There was no need for Karen Reed to do anything but call 911, which she never did. Instead, she's waking up Kaylee by shaking her, leaving the room, coming back with her phone, demanding that she text,
Right.
call people, get numbers, text her uncle, and it just, I would think that with a fair-minded jury, I would think that would be a strong claim, that you would have to know, knowing her background, you would have to know. I mean, it would be another thing if it were some kind of essential way to get help, but there were so many other ways that Karen Reed.
Yeah.
My feeling is that she never got help for John. Everything she did was to help herself by bringing in other parties and mixing it all up and getting other people to call 911 so she could later point the finger at their 911 call. Maybe it looks suspicious.
Yeah.
All sort of, I mean, it's interesting that this is, to me, that this is the way that she's defending herself again, once more, in this civil suit. Bring in other parties, deflect attention away from myself, and bring in, when you bring in other people, everybody has faults. Everybody falls short at one time or another, or maybe does something that's, isn't the best. And so but compared to it, and it worked. In the criminal trial, it worked. So.
Yeah, and one of the interesting things, looking at certainly Kaylee is the most sympathetic of all the plaintiffs here in a sense. I mean, John certainly, because he's not here anymore, but this kid who had lost her parents and, as the court says in its own decision, is a very vulnerable individual, et cetera, emotionally, and then to once something else you touched upon a moment ago was, bringing in all these other people. I mean, listening to Karen Reed's attorneys, both in that hearing and obviously in past statements, they are alleging an incredibly vast conspiracy, if you believe them, an incredibly vast conspiracy of people doing things to cover up what they claim actually happened at the Albert's place. As a plaintiff attorney, okay, and if they're bringing these claims, they are effectively plaintiff's attorneys, bringing either a third-party action in the context of this wrongful death case, or bringing a separate action. Again, they're going to probably sue for malicious prosecution. That's one thing. I get it. But all this other stuff is a whole nother animal. And you have a really high bar to meet to prove a conspiracy of this grand scale. I'd be very curious to see what kind of evidence they have, because you remember, I mean, you played it, I think, at the beginning of our program this evening, and Karen Reed and one of her defense attorneys are being asked, well, who did it? And they're like, we don't know. Somebody else was responsible, but we don't know. And then later on, now they're saying, oh, we know, everybody knows. And it's going to be, I don't know. I think I'd be concerned they were biting off more than they can chew. I mean, it's one thing to go and say, hey, we beat the criminal charges. Now we're going to sue for malicious prosecution, claiming you shouldn't have prosecuted her in the first place. Okay, whatever. You can have intellectual disagreements on either side of that argument. But taking it to the next level of this, vast conspiracy that I believe her attorney at the hearing in September said that the Alberts, the McKays, and Higgins diverted attention away from them and onto Karen Reed, such that the law enforcement folks involved then, bid onto this, if you will, and went running in the complete wrong direction of, who the actual killer was, they claim, which presumably was Brian Albert, Nicole Albert, Jennifer McKay, Matthew McKay, or Brian Higgins, because they were the only other people in the house at the time.
Right. Right.
But at least that's what I'm assuming they're going to claim. But good luck proving it.
Right, I know. They actually proved that it couldn't physically happen, just the timeline.
Yeah.
The car was already on the way to the Sally Port when they're finding pieces of her taillight. But very much like Garrett Phillips, like the Garrett Phillips case.
Yeah.
I was looking at a video of you on YouTube, you're talking about your work. And right under it, they're talking of, someone's leaving a comment related to the alternate suspect. That's also been proved. He was on a video walking his dog in that case.
Yeah.
Couldn't be. Doesn't matter that it's physically impossible.
To touch on that for a moment, Roberta, So put the video aside for a second. Nick Hillary, his supporters, all of the reasons why they claimed it couldn't have been Nick, okay? For each and every one of those reasons they claim it couldn't have been Nick, they apply even more so for John Jones. No fingerprints of his John Jones's DNA didn't. I mean, Nick Hillary, we know about his DNA, but John Jones's DNA didn't match anything. And then, he's on 3 or 4 different video cameras walking his dog at the time of the murder. I was just telling someone this story the other day, by the way, Roberta, where forgive me because I don't recall the press outlet. There was a reporter who was certainly in Nick's camp, shall we say. And this was in, I want to say, August 2016, approximately a month prior to the criminal trial in that case. And one of Nick's attorneys had given a statement to either North Country Now or the newspaper up there, in which he said that John Jones and Garrett Phillips had this argument / altercation out on the street on Cottage Street in Potsdam, 15 minutes before the murder takes place. And I played for her the security camera footage from the hospital that showed Garrett Phillips rip-sticking his way down the street and out into oblivion, and John Jones eventually pulling into his driveway, and the two never even passing one another, let alone speaking to one another. I can still remember she said, "Oh my God, why would they have lied to us about that?" I said, "You got to ask them." Anyway,
it's what they do. It's what they do in these innocence fraud campaigns, and people believe them. And it's just amazing how much the jury did not follow. I mean, there's so much evidence in this case. Dean Walker, thank you very much for the super sticker. Kitties, thanks for being a member. Turn my volume up. It's up. It's up now. Thank you for alerting me to it. I wanted to ask you about her pleading the fifth in this case. And I also have a question about, I thought the way that she was going to go, just because I'm so familiar with innocence fraud and how it works, usually they clean up in our civil courts with a claim of something like malicious prosecution.
Mm-hmm.
In this case, she was found guilty of driving drunk. So they can't say that she was held against her or they, limited her right to movement or whatever. I know there's another word for that, but, violated her
unlawfully
rights
detained. Yeah.
Unlawfully detained. So what kind of things do you have to prove in malicious prosecution?
So, much like the name implies, you have to prove that this prosecution was undertaken maliciously, meaning they didn't have, and they should have known that they didn't have a viable basis to bring the claims. I mean, there's the case law is legion in federal claims of proving and disproving malicious prosecution. But it's also, again, it's somewhat of a high bar for the plaintiff. I mean, look, she was acquitted on the criminal charges related to the murder. We know that. She got convicted on the drunk driving charges. It's I think in the end, much like, Nick Hillary did the same thing after his acquittal. He brought malicious prosecution claims against everybody and their brother. Every single one of them was dismissed. In fact, every single claim Nick brought in any civil suit anywhere was eventually dismissed either by a judge or a jury. I think Karen's going to have a tough time. You mentioned at the beginning about pleading the fifth, and I'm not sure I caught all of that. What were you asking about that?
So in this case, can she plead the fifth on the stand? They can't try her again, obviously. What options does she have for pleading the fifth? Does she have to take the stand?
So very good question. So number one, again, she was acquitted on the criminal charges relating to the murder. Can't be prosecuted again, double jeopardy. And then she's convicted of the drunk driving charge. And if I recall correctly, I don't think she appealed anything in relation to that. So that stands. So there isn't any basis by which I can see that she could viably plead the fifth, because there's no jeopardy that she could be placed in for anything that I can think of at all. And the problem she has pleading the fifth, let's just assume that's something that she does, is, in civil cases, especially, again, if she files malicious prosecution and various other claims against the Massachusetts State Police and its members and various other individuals, in civil cases, I know this is a double negative, and my English teacher, Mrs. Seiler from elementary school, would be mad at me. You can't not testify. If you plead the fifth in civil cases, it's going to be a big problem for you. You're going to basically have it held against you in a bad way. Unlike the criminal side, where pleading the fifth, it can't be held against you. Blah blah blah. We all know that stuff. And in the civil world, it can really bite you in the what. And again, for her as a plaintiff, and this was the same thing that happened with Nick Hillary in his civil cases, was he had to testify. If he didn't testify on his own behalf in civil claims that he brought, and again, if she doesn't, she takes the fifth and refuses to testify on civil claims that she eventually brings, those claims will get dismissed. So I don't see any path for her to do it, especially given the fact that the criminal charges have all been resolved and there's no jeopardy for her. So I don't see a legal basis by which she could, and I'm not a criminal attorney, but still, I just don't see it.
Yeah, so she's going to have to take the stand, or
Oh, yeah.
Oh, wow.
It's like OJ when he was a defendant, in the Goldman family wrongful death cases, after he was acquitted, he had to testify. She's going to have to do the same thing, and you can be rest assured they're going to videotape those depositions, and I'm sure they'll be ending up on TMZ or something somewhere.
Oh, definitely. And a curious thing at the end of this hearing, they said, this kind of goes into Maestro's question, which is, how would you try this knowing the cameras are there? They said, do you want to do this on Zoom or do you want to do this in person? They all wanted to do, the defense wanted to do this in person, the
vice versa. It was vice versa. So what the judge was simply talking about was the November 21st next court hearing.
Right.
And it was simply a matter of, hey, folks, if you all want to do it on Zoom, that's fine. So we don't all have to pile into the courthouse. It was merely the judge being kind to all the attorneys and saying, if it's easier for you all to do it on Zoom, let's do it on Zoom. Otherwise, if you really want to be here in person, fine, we'll do it in person. And I believe the defense attorney, if I recall, said, I'm agnostic on this. And the judge said, you're agnostic? And he says, yeah, I don't care, whatever you want to do. And that was Ms.
I thought it was Karen's attorneys who all wanted to come out.
They wanted to come. Right. No, Karen's attorneys wanted it in person.
Yeah.
Because they want the publicity.
Absolutely. So, is there anything, have you ever tried a case on that it's been broadcast? And what do you think about cases that are broadcast, and how would you adjust for a case being
So
broadcast?
New York is a little bit arcane in a sense that it is exceedingly rare to have cameras in the courtroom. We had them in the courtroom for a period of time about early part of my legal career in the 90s, and I want to say around 2000 or so, there was a sunset provision in the law, and they allowed it to sunset for reasons I do not know. And then after that, generally speaking, you have to have extraordinary circumstances to allow cameras, and they will typically only allow them for parts of a trial, usually closings and openings, or openings and closings. The only case I had on the civil side of the world that we had that was back in 2010. I was involved in a 7-week trial up in Lake George, New York, that involved the Hadlock Pond Dam failure, and it was effectively like the Hurricane Katrina for that small community up there. Okay, so it got a lot of local press, and TV cameras were there during the opening arguments, TV cameras there during closings, and the gallery was packed with the reporters during the bulk of the trial. It doesn't change for me, okay, personally. It doesn't change what I do. I'm going to go in there. I'm going to try my case. It doesn't matter what the gallery thinks. It matters what the folks in the jury box think. And, you know, eventually they're not paying attention either to, typically, hopefully, they're not paying attention to what's going on in the gallery. And you want them, if you're doing your job properly, they're paying attention to you and not people watching.
Yeah, that's true. One more. I mean, let me see. We know that Karen Reed. This is the last clip I have to show you. Went on her South African lawyer, Damon Seligson, went on Howie Carr's radio show, and am I all the way? Yep. Okay, and he said that they're going to file these motions against everyone very soon. Take a listen.
That's the answer we filed. We have, as we alluded to in court at the last hearing in September, we are well underway in terms of bringing to the court's attention our efforts to bring in the folks that we believe are responsible for the malicious prosecution and who are responsible for John O'Keefe's death, and that's imminent. I can tell you that.
Oh, when you mean imminent, you mean a court filing, or what exactly are you talking about?
So what you typically do when you're a defendant in a civil case such as this, in a wrongful death action, for example, and you're claiming that other parties should be brought into the lawsuit, or you have claims, you typically have to file them at the time of your answer, and you would typically say, if I have counterclaims against the plaintiffs, you bring your answer and assert counterclaims. We do not have counterclaims against the O'Keefe family, or you have cross claims against the existing defendants. We do not have cross claims against the two taverns. What we are going to be bringing in imminently is a motion with an attached complaint to add other parties to the complaint, to the lawsuit, in line with that affirmative defense that you read to your audience. That's a teaser of what's coming. We're working on it, and within days, we will have this served on all of those parties. They will have an opportunity to respond, and hopefully it will be in front of Judge O'Shea in advance of the next hearing on the 21st of November.
Okay, so he says it's coming. It's coming. I mean, what are the chances, just knowing how much of this has been played out in the court of public opinion and in the media, what are the chances that they never file this? Is there a chance that they never file this?
I think that chance is somewhere between 0 and 5% that they never file.
Okay.
I think they're going to file, at a minimum, they're going to file a malicious prosecution claim. Whether or not they include all of the other conspiracy theories and things that they alluded to and mentioned in the September 22nd hearing, I don't know. And to pick up on what he was talking about, and the court talked about this a little bit in that hearing in September, there are a couple different ways you can go about doing this. Again, there's one way. Karen Reed's attorneys can file a separate action against all of these folks in Massachusetts state court and try to get it consolidated with this existing action. They would have to file a motion to consolidate or join these things together. Again, there may also be issues of removing to federal court, or they can go the path of, and which is what it sounds like he was talking about on the Howie Carr show, was they're going to file what's called a third party action. So again, Seligman said, you can assert as a defendant counterclaims against the plaintiff. They don't have any, so they can't do that. They can assert, which they already did in the answer, something called affirmative defenses. And affirmative defenses are literally what their name implies. There are defenses you as a defendant are affirmatively stating and claiming for which you believe you're not responsible for what happened, or you claim the plaintiff was somehow responsible or whatever. And because they have an affirmative defense of, hey, we believe other parties are responsible, to elaborate on that and actually put it into a pleading, you would bring a third-party action. So it would be O'Keefe's versus the Bars and Karen Reed, and then Karen Reed as what's called a defendant, third-party plaintiff versus, this litany of entities. And then you have to serve that on all of those entities and individuals, and then they have an opportunity to respond with either motions to dismiss, removing it possibly to federal court, or severing the third-party action, removing it. I mean, it's, like I mentioned earlier, it's going to be procedurally quite an interesting quagmire, depending on the claims asserted. A malicious prosecution claim is strictly a state court claim. A violation of civil rights is typically a federal 1983 claim, and that typically you'll litigate in federal court. I mean, it can be litigated in state court, but normally as a defendant, if you have an opportunity to remove a case to federal court, you do, because you generally want federal judges dealing with federal questions. So anyway, probably way longer of an answer than you needed.
No, and it looks like just... I don't know. I'm curious to see what kind of judges are sitting in federal court in Massachusetts. Curious how they would take these claims. The other thing I wanted to ask is about Karen Reed. Says the O'Keefes have unclean hands. What does that mean? And can you explain the logic behind that defense?
So, which is interesting. So it's an affirmative defense that they state in their answer. And typically as a defendant in civil cases, two things. One, you deny almost everything that's in the complaint. If they allege 2 + 2 is 4, you deny it. Almost everything gets denied. That's very common. Second thing is affirmative defenses. As a defense attorney, you want to throw out every single possible remotely applicable affirmative defense that can be there, because if you don't assert one, you can be barred from making that claim at some later date, at trial, and especially. So unclean hands is essentially what you're saying is, hey, wait a minute. While plaintiff, you're saying I'm responsible for this individual's death and the damages that were caused, you're also responsible in some manner or form. It's a very generic thing, but compare and contrast that to what Seligman said in the Howie Carr interview of, well, we don't have counterclaims against the plaintiffs here. We're not claiming anything against the plaintiffs here, which is, again, a counterclaim is technically a different thing than an affirmative defense. It's where you are affirmatively making a claim back against the plaintiff for your own damages. Which happens in some civil cases, not really applicable in one like this, but it's just interesting to hear the juxtaposition of, hey, plaintiff, you have unclean hands, and wait a minute, we're not asserting any counterclaims against them. So while yes, they are legally, technically different things, they're kind of like twin sisters, they ride around together legally, if you will. So it was just interesting to hear that.
Yeah, it's odd, right? Yeah, odd. Very Karen. Does anybody have any questions before I head off? I think I missed one from Meister. I think I missed one. Hold on one second. Sure. Did Tom represent? Oh, here we go. Didn't Tom represent New York police officials? Has he seen anything like Michael Proctor's personal messages being brought in as evidence? I don't know how familiar you are with the Karen Reed case. Do you know about Michael Proctor? He had used his personal phone and then all his personal messages to his friends, his buddies on a group text came in, and they were very not complimentary towards Karen Reed. He's talking about her body and her being a whack job. See you next Tuesday, and that kind of. I remember got fired for it.
generically hearing about it or reading about it in different of the press things that I either read or saw. I remember that. To back up, so the person asked the question, I've never represented the state police. They are, in New York at least, the state police are typically represented through the New York State Attorney General's office, and the members of the state police are usually represented also through the AG's office, although sometimes you have a circumstance where there's arguably a conflict of interest, so the individual member will have private counsel. All of my law enforcement cases, I was representing sheriff's departments, city police departments, things like that. So I didn't represent the state police. That said, in the context of that criminal case, because of, the discovery obligations and stuff, basically everything that he was doing on his phone related to the case became discoverable and fodder for the defense team to use, and it will surely be part of the whatever aspect of civil case Karen Reed eventually brings that he's a defendant in, certainly. Because the discovery rules, by the way, in civil, you get, not only will they get to depose, so again, if Karen Reed, whether she brings it as a third party action or she brings it as a separate action, Karen Reed ultimately her attorneys would get to depose these people under oath. In a criminal case, they don't necessarily, the DA's office doesn't necessarily have to put them on the stand, and they might not be directly relevant to a defendant's claim. So, and they'll get to, see all this stuff ultimately, and whether it's going to be relevant in front of a jury is a whole nother issue. Because again, it's, after the fact stuff, although I think Karen Reed's team will claim it was part of this whole law enforcement cabal that they've alluded to having.
Conspiracy.
Yeah.
Funny. Anybody else have anything else before I head on out? Because I think I think it's a pretty fascinating case to watch. It seems like, here, Patricia has one. Does Tom have an opinion on Judge Bev's judging? Did you watch any of either trial?
You're talking the criminal trials? No, yeah. I only saw snippets. I did not do any type of deep dive into watching. So I read stuff, and various people have said stuff about the criminal trial judge. I don't have enough information to say one thing or another.
It's interesting because it's the one thing I think that both sides agree on, the Karen Reed supporters and the Karen Reed non-supporters agree on, is that this judge was awful. I think for different reasons, but for both. And she moved from criminal court. She's now in civil court. So my fear was that she would be presiding over this case. Thought, not again.
Right.
So it's nice to have a different judge who's a little bit more fair it looks like to both sides. Tom Mortati, thank you so much for doing this. I really appreciate it, and I know people in the chat appreciated it. You really explain a lot of complex things in a way that everybody can understand.
Well, you're welcome, and this case is obviously going to be going on for a while, and it's sort of going to become, in some sense, a legal car wreck at the side of the road. Everyone's going to stop and watch this thing, including you and me.
It may be the first, or one of the first, I guess since Johnny Depp, the first civil trial that will be broadcast with much fanfare. Yeah,
I think you're right about that. So, hey, well, listen, I look forward. Well, I'm sure we'll have an opportunity to talk more, because and I know there's going to be twists and turns on this legal path, especially with all this procedural stuff that should be coming up in the near future, actually.
For sure. Tom Mortati, thanks so much. And everyone, thanks so much for listening. Please hit the thumbs up on your way out. Have a great night, everybody.
Take care, Roberta. Nice talking to you again. Bye-bye.
Nice talking to you.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment. I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system I clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, gin, like John, you were my mark. My innocence fraud campaign is my biggest hit. I pushed the pedal down, hit him hard. Now the legal system I clown.